None appears for the petitioner. At the time of call, no accommodation has been paid for either. In view thereof, let this matter go out of the list. Yes, call the next matter.
Item number 25.
And for the petitioner husband.
Yes,
The
what do you want?
petitioner husband has challenged the order dated 21st July 2020, whereby maintenance under section 24 was enhanced from 9,000 to 25,000 during pendency of the
What is
matrimonial.
your take-home salary?
86,750. But I have shown my expenses. I have my aged mother to.
After considering those expenses, how much it has come down to? 20,000.
No. It has come down to
Then-
46,000 something. After statutory deductions, it has come to down 46,000 something.
Statutory deductions. What are the nature of statutory deductions? From 86 to 46,
My lord,
40,000 statutory deductions.
My lord, kindly come to page 7.
Show me your pay slip. Statutory deductions of,
It is annexed.
yes, page
166 pay slip.
166.
166.
Yes. What is the deduction on 13,000? What is the
13,000?
deduction on account of 14,000?
That
Are
is
those statutory deductions?
what happened, my lord. I'm
What
going
is the
back to
stage of the suit?
argument is going on in the law
Argument,
by the both side. The
evidence completed.
evidence completed.
Yes.
There has been expeditious disposal of the suit, so the matter is going on there. I am not saying that I will not pay, but consider the quantum of the 25,000 from 9,000 to 25,000. It has been very difficult for me to continue. I am not saying that I will not pay, but some concession may be granted.
How much you are paying now?
25,000 because there is no stay. It is
You are paying.
yes, I am paying because there is no stay.
What is the next date fixed in the suit?
First December 2023 for argument by the respondent because they have completed their evidence last.
So only 1 month. I will direct it to be disposed of in course of this year. Otherwise, service, it is to be stayed.
I'm just beseeching one order that till this
It cannot be reduced without hearing the other side.
Yes.
Then I can stay the proceedings of the suit.
No.
So I'm directing the suit to be decided within the time. The petitioner, being the husband, has filed this civil revision application under Article 227 of the Constitution of India, challenging an order dated, challenging an order being number 176. So many number of orders in a
Yes, it has been pending for
challenging
more
the
than
number.
12 hours.
Order
12
number
years.
176 dated July 21, 2023, passed by the learned additional district judge, 10th court at Alipur, paragraph. By the order impugned, the learned trial judge directed the
My lord, I want to submit.
husband to pay. You also have a daughter.
Yes, but she has
Directed
become
the
major.
husband to pay a sum of rupees 25,000 per month. Pay na kore. By the said order, the learned trial judge, director aage likhun, enhanced the amount of maintenance pendentility from 9,000 to 25,000 per month. Full stop. After going through the impugned order, this court finds that the gross salary of the petitioner is rupees 86,570. Full stop. The learned trial judge, while fixing the amount of maintenance pendentility, have taken into consideration the fact that the daughter of the parties is a college student and her educational and miscellaneous expenses cannot be ignored. Full stop. The learned trial judge, after taking into consideration the income of the husband and after considering the statutory deductions therefrom, arrived at the directed the husband to pay alimony pendentility at the rate of rupees 25,000 per month. Paragraph. The learned advocate appearing for the petitioner submits that what is the next date fixed?
1st December 2023.
That December 1, 2023 has been fixed for argument in connection with the matrimonial suit. Full stop. The order impugned is supported by cogent reasons. Full stop. In view thereof, this court is not inclined to interfere with the impugned order. Full stop. However, taking note of the fact that the matrimonial suit has already been fixed for argument, CO number such and such is disposed of by requesting the learned additional district judge 10th court at Alipur to take up the to dispose of the matrimonial suit number 1023 of 2014 on or before the end of January 2024 without granting any unnecessary adjournments to either of the parties. Next.
I'm great.
Item number 26.
I appear for the petitioner, my lord.
Yes.
Petition is a plaintiff in the court below, my lord, suit for specific performance of contract, my lord. In the suit, my lord, I have filed an application for injunction and obtained an order of injunction restraining from the defendants from creating third-party interest in suit property, my lord. Subsequently, my lord, defendant are trying to induct third party in the suit property, and my lord, they have keeping sanitary goods in the common passage, my lord. I filed 2 applications, my lord. Order 1 Rule 10 application and Order 13 Rule 7 application. Both applications were rejected, challenging which I come up before your lordship. My lord, in the Order 1
Rule 10.
Order 1 Rule.
How is the necessary party?
My lord, since my lord, he is trying to take the portion, occupy the portion. That is the reason why I kindly consider 39 Rule 7 because he is keeping.
39 Rule 7 I will hear first. First, address on Order 1 Rule 10.
Since my lord, he is keeping goods on the common passage, my lord. That is why I want to make him a party in the proceeding.
What is the reasoning assigned by the learned trial judge? Come to that.
Kindly comes to my lord. Third paragraph, my lord. Here about the said order of the court, the last part of the December 29 have been able to take part with the possession with one Manoj Kumar Rai, who has.
Where is your application under Order 1 Rule 10?
Kindly come to page page 13, my lord. The reasoning in the objection, they have stated that this person is coming to the suit property to look after his aged mother. Although, my lord, the aged mother died in 2016 itself. They have filed an Order 22 application, we have annexed, my lord, where they have only stated that mother has died 29 December 2016 at page 28, my lord.
Yes, where is your application under Order 39 Rule 7?
Kindly come to page 20, my lord.
Yes. What are the points of local inspection?
Page 22, my lord.
Yes. How local inspection is
Since,
necessary for the purpose of deciding the merits of a suit for
since there is a specific order of injunction, my lord, they are trying to,
violation.
yes, order injunction does it.
Where is your allegation for violation?
But they are kindly seized, my lord.
You have not taken out any application for violation also now. The petitioner has challenged an order being number 153 dated 27th of July 2023, passed by the Learned Civil Judge Senior Division Second Additional Court at Bardwan in title suit number 75 of 2014. You have only challenged order 1 rule 10, not order 39 rule 7.
Kindly, my lord, seize, my lord.
Preamble, grounds, paragraph, nowhere. You know, by virtue of which the application under order 1 rule 10 of the Code of Civil Procedure was rejected. First up, though by the said order, 2 other applications, one under order 39 rule 1 and 2 and the other under order 39 rule 7 of the code was disposed of, but the same has not been challenged by the petitioner in this revisional application. Therefore, this court is only concerned with the order passed in connection with order 1 rule 10 of the Code of Civil Procedure. First up, it is well settled that in a suit for specific performance of contract, only the contracting parties are necessary parties to such a suit. First up, the learned advocate, it appears from the application filed under order 1 rule 10 that the plaintiff seeks to add one Manoj Kumar Rai, who has allegedly kept sanitary articles over the common space of the suit property. First up, such cannot be a ground for adding Sri Manoj Rai as a party in a suit for specific performance of contract. First up, the learned trial judge have assigned the order impugned is a reason 1. Therefore, this court is not inclined to interfere with the decision of the learned trial judge. First up, CO 3097 of 2023 accordingly stands dismissed without offer. Any order has to pass.
It's kindly grant me liberty to challenge the order 13 rule 7.
Order 39 rule 7. Yes, then yes, you place your then file it in. Yes, you make move your.
No,
Yes, I am allowing him. Yes, place your case. The learned
kindly don't.
লিখে দিন নাহলে ওখানে যারা লিখেছিলাম না ওই দুটো ওই অন্যটা করেনি তাহলে ওখানে কেটে
Kindly do not, my lord. Kindly do not.
the though it appears from the petition that the petitioner has challenged only the order passed in connection with order 1 rule 10 of the code, the learned advocate for the petitioner submits that the petitioner has in effect challenged the order passed under order 39 rule 7 of the code also. This court therefore permitted the learned advocate for the petitioner to make submissions insofar as the order passed by the learned trial judge on an application under Order 39, Rule 7 of the Code is concerned. Yes, Mr. Bhattacharya, make your submissions.
Kindly do not, my lord.
No, you make your submissions. Now I have to record. I will give my findings.
Kindly do not, my lord. Kindly do.
Make your submissions, I will pass the order. So, after going through the application filed under Order 39, Rule 7 of the Code, and considering the fact that this is a suit for specific performance of contract, this court is of the considered view that the learned trial judge was perfectly justified in rejecting the application filed under Order 39, Rule 7 of the Code. ঠিক আছে? বলে করে দিন। Thank you. Yes, next. ঠিক আছে, ওখানটা change
Item
করে
number
দেন।
27.
হ্যাঁ, হ্যাঁ। 27, yes.
Lord, I am appearing on behalf of the petitioner.
Yes, what do you want?
Lord, by virtue of the order impugned, Lord, my application for handwriting expert has been turned down. My Lord,
Has been
turned down.
turned down, yes.
My Lord, suit for, my Lord, declaration that the scheduled property has been void.
Has been,
Void.
kindly use the microphone.
My Lord, suit for declaration that the deed executed by Nader Hossain mentioned in schedule, my Lord, that is void. My Lord, I filed an application for handwriting expert that has been turned.
What is the relation between that
Nader
Nader Hossain and yourself?
My Lord, I am the son of, my Lord, the first wife, and my Lord, the defendant is the son of the second wife.
What is the nature of the deed which you are challenging?
My Lord, that is, my Lord, gift.
Gift deed.
Mal.
Both the deeds are gift deeds.
Both the deeds are gift deeds.
What
My
is
Lord,
the
kindly-
ground of your challenge?
My Lord, ground of challenge, my Lord, that Nader Hossain, my Lord, in the year 1989, executed two deeds. There he signed.
No, that I appreciate. You want to compare the signatures with the admitted signatures. What is the ground of challenge to those two gift deeds?
My Lord, that he never executed any thumb impression. He all along in every document he signed.
What is the stage of the suit?
My Lord, suit fixed for argument.
Argument. At that stage, you have filed an application for appointment of an handwriting expert
My Lord,
or LTI expert.
my Lord, kindly comes to my Lord,
Handwriting or LTI?
LTI.
Yes.
My Lord, kindly comes to page 24, my application.
24.
My
Yes.
দরখাস্তকারী বাদী পক্ষের নিবেদন এই যে বাদীগণ নালিশি দলিল কার্যকরী ভয়ের দলিল থাকা সাব্যস্তে চিরস্থায়ী
Have you annexed the plaint?
my lord,
Page.
my lord, page 12.
Yes. Yes, place the impugned order.
My lord, it has been turned down on the source code that it is a registered document. That is why, my lord, kindly comes, my lord, the third page of the order impugned.
Yes.
My lord, second paragraph, it should not forgotten that section 34 of Registration Act,
Page. Yes, I've got.
my lord, internal page 3. My lord, the second paragraph, it should not be forgotten that section 34 of Registration Act, 908 stipulates inquiry before registration by registering officer. Moreover, as per Rule 21 of the West Bengal Registrations Rules, so and so, without fulfillment of the conditions mentioned therein, not a single instrument cannot be admitted for registration. Both the original registered impugned Hevanama on record features endorsement of the district registrar Murshidabad that a persons, namely Nader Hossain, physically presented the deed for registration. Neither in their pleadings nor in their evidence the plaintiff brought any allegations against registering authority. Even the district registrar Murshidabad has not made party in so and so. On the source code, my lord, it is a registered document. My application for scientific expert of thumb impression, my lord, has been turned down.
আসুন, the petitioner has challenged the order number 68 dated July 21, 2023, passed by the Learned Civil Judge, Junior Division, Additional Court Lalbagh, District Murshidabad, in title suit number 247 of 2015. First up, by the order impugned, the application filed by the petitioner herein for appointment of an expert for comparison of the signatures and LTIs of the executor of the deeds being number 5826 dated 13/5/1996 and number 5825 dated 13/5/1996 with the signatures and LTIs of the executor of the registered deeds being number 6633 dated 2/11/89 and being number 8 dated 2nd November 1989 and being number 8811 dated 9th of October 1985. First up, the learned advocate appearing for the petitioner submits that the learned trial judge rejected the prayer for appointment of an expert only on the ground that the deeds which are under challenge in this suit are registered documents. First up, paragraph. After going through the impugned order, this court finds that the learned trial judge recorded that the plaintiff in the affidavit in chief have stated that they have acquired knowledge as to the existence of the registered impugned Hebanamas only after 27th of August 2011, but from the certified copies of such deeds produced by the plaintiff, it appears that the plaintiffs were aware of the registered impugned Hebanamas dated 13/5/1996 since the year 2003. Full stop. The learned trial judge also took note of the admission of PW1 in cross-examination that their father, Nader Hussain, executed both the impugned Hebanamas in favor of the defendants. First up, on a query of the court, the learned advocate for the petitioner submits that the application for appointment of an expert was made at the stage of argument. First up, after going through the impugned order, this court finds that the same is supported by cogent reasons. In view thereof, this court is not inclined to interfere with the order impugned. Full stop. CO number such and such accordingly stands dismissed without, however, any order as to costs. Urgent Xerox certified copy. Yes. Call the next matter.
Lord, next matter is identical matter. My lord.
Other OS.
My lord, the deed
Same order.
number- Deed is different.
Yes. Two suits.
Two suits, my lord, deed number.
Next same order.
85.
শুধু suit numberটা change হবে। ঠিক আছে। Yes. Call the next matter.
Item number 29.
Yes, 29.
I have instruction to oppose this application.
Instructions to oppose. Who has instructions to propose? Yes.
My lord, transfer matter, I am for the wife from Barasat to Alipur.
Barasat to Alipur. Where
Yes.
are you staying?
And I stay in Goria, my lord.
You stay in
I stay in, I stay in reside in
Dhakuria.
Dhakuria, my lord.
So,
And the husband stays, my lord, in Bidhannagar, Rajarhat, my lord. Kindly see his address, Bidhannagar. So from Bidhannagar to
what is the
Barasat,
stage of the suit?
my lord, initially filed. Just now filed. Date has been given on 11th January 2024. After filing the suit, my lord, I have filed this section 24 application.
First time I don't have the copy of this application.
You have not served the copy.
First time,
time.
first time.
Only my instruction that she is a practicing lawyer of Alipur.
She's the practicing lawyer of Alipur.
No, my lord.
Is it so?
My lord, she is a housewife.
I have received.
She got enrollment,
Or-
but she is not practicing, my lord. This housewife, my lord, today is 49 years of age. So what practice, my lord, she will?
Did she obtain an LLB decree? Yes or no?
Yes. As per my oral,
Told with the Bar Council of India, West Bengal.
as per my oral instruction, my lord, yes.
Cannot be Alipur.
Any place, my lord, your lordship.
So let it be where it is.
Barasat, my lord, it's, my lord,
Too far.
too far
You
from.
will not go to Barasat court if you
My
get
lord,
a
I don't have a
client-
car. I don't have a car. He has a car.
If you get a client to conduct a case at Barasat, you will not be going.
But that I will be going.
Yes.
But the difficulty for the client, my lord, kindly, wife, my lord, kindly, my lord, age, my lord, kindly see, my lord, 49 years.
Where is that
Having-
Supreme Court judgment? You have not brought.
The first time I do not know the ground detail.
The
And a lady, my lord, also, my lord, kindly visualize, my lord. I am for the wife, my lord, kindly.
have you stated this fact about that? She is an LLB graduate. She has been enrolled. Have you stated these facts?
My lord, she is, my lord,
Have you stated these facts?
my lord, no, my lord.
Why?
Recently, my lord, she has been
Why?
enrolled. This year, my lord, she has been enrolled. I think so. This year she has been enrolled.
Yes. So before filing or after filing of the revision application, she has been enrolled.
I think, my lord, before.
Why it has been not been disclosed?
She is housewife, my lord, she is not working. Maybe a person is enrolled.
File an affidavit to that extent that you are not working.
Yes, my lord, that I will. That I can. That I
The
can. I don't have any, my lord, personal source of income.
that is
also.
a different thing altogether.
So, my lord, if
That is a
someone-
different thing altogether.
my lord, if I am,
You do not have any source of income, that is
my lord,
a
if
different thing altogether. But you have been enrolled as a lawyer. That
Well,
fact has not been disclosed.
enrolled, my lord, but I don't practice, my lord. I don't practice, my lord. That is the fact.
Don't take that risk of stating that in affidavit.
My lord, there are lawyers.
Don't take that risk. This is an application under section 24 of the Code of Civil Procedure for transfer of the matrimonial suit from the Court of the Learned District Judge at Barasat to the Court of the Learned District Judge at Alipur. First up, the learned advocate for the opposite party appears and submits that he has instructions to submit that the petitioner is enrolled as an advocate with the Bar Council of West Bengal. First up, however, after going through the application, this court does not find any averment to such effect. The petitioner is granted leave to file a supplementary affidavit stating as to whether she has been enrolled as an advocate with the Bar Council of West Bengal. Now, তার আগে লিখুন, she has obtained an LLB degree and has been enrolled as an advocate with the Bar Council of West Bengal. Full stop. Let such supplementary affidavit be filed
by next week, my lord.
within a week from date. Full stop. Petitioner is directed to serve a copy of this application along with the supplementary affidavit upon the learned advocate representing the opposite party. Full stop. Leave is granted to the opposite party to file affidavit in opposition to this application, as well as to file a composite affidavit in opposition against this application and the supplementary affidavit within কি এটা চলে গেল তো, ক্যালেন্ডার চলে গেছে, ক্যালেন্ডার কোথায়? Within a week after reopening of this court after Puja vacation. First up, list this matter in the monthly list of December 2023 before the regular bench. Yes,
My lord, in the meantime, a stay may be granted, my lord. In the meantime,
don't press for stay, otherwise
my lord, wife, my lord, will be suffering, my lord.
then you can move. On merits, I will decide this.
My lord. Then, my lord, kindly fix a date, my lord.
This is a concession given prior to the Puja vacation. Otherwise, I am not satisfied with that. Serving directions for service also. This is a concession since it's before Puja vacation. I have given you that leave.
Wife, my lord, with old aged mother, my lord, and having several serious.
State that by way of those facts by way of a supplementary affidavit. Thereafter, those facts have been suppressed. Yes, next.
Item number 30,
My application. For
Yes.
expeditious disposal of the suit, my lord.
Of suit.
Suit.
What is the nature of the suit?
My lord, order 1 rule 10 application was filed by the defendant
Order 1 Rule 10 is pending.
pending, and later on, after the application has been filed.
What is the nature of the suit?
My suit for eviction and declaration and injunction is filed in the year 2008, my lord.
Application filed by you.
Not filed by third parties.
And what is the stage of the suit?
The suit is pending for application interlocutory hearing. The application,
Peremptory hearing. Ashun.
my lord, expeditious.
This is an application for Bosoli. This is an application for expeditious hearing of an application.
Of the suit, my lord. That the application has been.
This is an application for expeditious hearing of title suit number 508 of 2018 pending before the learned civil judge, Junior Division, First Court at Howrah. Full stop. It appears from the record that an application under Order 1 Rule 10 within bracket 2 of the Code of Civil Procedure is fixed for hearing.
My lord, subsequently, after the suit was filed, the application under 220, I have taken instructions that sometime in last week of September, the application has been allowed, this
It
application.
has been allowed. Order 1 Rule 10 has been allowed.
We are filed.
What is the next?
December,
Then he has been allowed to file written statement.
that we are taking steps to file another revisional application.
তাহলে কি বললাম? Was fixed for hearing on August 23, 2023. First of the learned advocate appearing for the petitioner submits that such application has been allowed sometimes in the month of September 2023.
Last week of September 20.
Sometimes in the month of September 2023. First of, since the suit is pending from the year 2018, CO number 3101 of 2023 is disposed of by requesting the learned civil judge, Junior Division, First Court at Howrah, to make all endeavors to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Yes, next.
My lord, within certain time.
Time limits difficult. Written statement, what other things at this stage? Be happy with this. Yes, next.
Item number 31.
I appear for the petitioner, my lord.
Yes.
Section 24 application, paying
Transfer.
transfer from Asansol to Malda, my lord. Act 8 case, my lord, I've already instituted 3 proceedings. One is 498 proceeding, 125 proceeding, domestic violence. Husband is contesting in Malda court, my lord. He has even stated in the petition
You
under
have brought that judgment of the Supreme Court. No. There is an application under section 24 of the Code of Civil Procedure praying for transfer of the matrimonial
no
suit,
Act 8 case, Act 8 number 16 of 2023.
praying for transfer of Act 8 case number 16 of 2023 pending before the Lanet District Judge at Paschim Medinipur.
Question Bardhaman.
Lanet District Judge at Paschim Bardhaman. Lanet District Judge Paschim Bardhaman at Asansol. To the Court of the Lanet District Judge Malda. Full stop. Petitioner is directed to serve a copy of this application upon the opposite party by registered / speed post with acknowledgement due and file an affidavit of service on the next date. List this matter in the monthly list of December 2023 before the regular bench.
I shall be praying for stay, my lord.
Yes, next, what is the stage?
Oh,
Only filed.
no, he has served notice, given last chance, my lord. Kindly, my
Last chance for what?
to or else ex parte stated that to last chance to contest the proceeding or we fix for ex parte. Kindly, my
To file your written
no,
statement.
no, not
File your written statement.
kindly make a short interim prayer, my short, kindly, my lord.
Yes, yes. Next.
Item number 32.
My application, my lord, the orders may be passed as similar to item number 30, my lord. Item number 30. the order
Item number?
30 that was taken up by my lord, the
Yes.
similar order may be passed. The parties are different only. And the title suit number, it's for expeditious disposal of the suit.
Expeditious disposal.
It's the same, the order 1 rule 10 application was filed and has been allowed.
Order 1 Rule 10 has been allowed.
Allowed. The time,
This is a different suit.
different suit. That was suit number, this is suit number, that is suit number
This is an
509.
application. This is an application for expeditious hearing of title suit number 509 of 2018 pending before the Lanet Civil Judge Junior Division, First Court at Howrah. So it appears from the record that the hearing of the application under Order 1 Rule 10 of the Code of Civil Procedure was fixed for hearing on, the hearing of the petition was fixed on August 23, 2023.
And the
So
same has
the
been allowed.
learned advocate for the petitioner submits that the said application has been allowed by the learned trial judge
Sometime in
sometimes in the month of
September.
September 2023. First up, CO number 3103 of 2023 is disposed of by requesting the Lanet Civil Judge Junior Division, First Court at Howrah to dispose of title suit number 509 of 2018 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Yes, call the next matter.
I'm good.
Item number 33.
Yes, Mr. Raut.
But I am of the opposite party.
Opposite party, yes.
In item number 33, Mr. Shovan Mukherjee is appearing for the petitioner, my lord.
Yes, yes. What is the
Yeah.
matter? Move, move.
My lord, he is not in court due to personal difficulty. He has prayed for not today.
Yes, striking out of defense.
File substituted defendant file an application 151 seeking permission to file 7-1. That has been rejected.
The original defendant filed.
Yes, for a revision, this, that, everything.
No,
Original defendant filed.
he also did not comply with.
And 12th October suit is fixed for hearing. On others, 12th October suit is fixed for hearing.
12th of October.
Now they have come forward.
My lord, I have no instructions. Sir.
You have no instructions. Ashun. The learned advocate for the petitioner prays for an adjournment. Such prayer is seriously opposed by Mr. Raut, learned advocate for the opposite party. First of it appears from the record that the defense of the petitioner herein has been struck off, and October 12, 2023 has been fixed for ex parte hearing of the suit. Full stop. Since a prayer for adjournment is made, let this matter appear before the regular bench. Let this matter appear before the regular bench. In the let this matter appear not let this matter be listed before the regular bench in the monthly list of December 2023. It is however made clear that pendency of this application shall not be a bar in proceeding with the suit. Yes, next.
Item number 34.
If it pleases your lordship, my lord, I beg to appear for the petitioners, my lord.
Yes.
My lord, in a suit for declaration and permanent injunction, my lord, I was the defendants, my lord, and decree holder, my lord. An appeal was preferred by the plaintiff, my lord, judgment debtor.
No, I could not follow.
I'm sorry, my lord. My lord, in a suit for a title suit, my lord, I was a defendant, my lord.
Yes.
That suit was decreed in my favor, my lord. I am a decree holder.
Suit was
Decreed against the plaintiff, my lord, in favor of the
that
defendant.
means the suit was dismissed.
Dismissed, my lord.
Why I was saying decreed in your favor.
So
that is why I got confused.
I'm sorry, my lord.
Yes.
The appeal was preferred from that dismissal order, my lord. We filed a caveat, my lord. My lord, without my lord notice to us, the suit was admitted, my lord. The appeal was admitted, my lord. Thereafter, my lord, the application under section 151 for stay was filed by the appellant, my lord, in which, my lord, there were 7 total defendants, my lord, but only 5 service was effected upon only 5. And under such circumstances, my lord, the stay was.
You have appeared.
I have appeared, my lord. My lord, but the stay was mechanically granted, my lord, without considering.
What is the effect of that stay? What is the effect of this stay which is affecting your right?
My lord,
How the stay order is affecting your right?
my lord, the petitioner in their suit prayed for, my lord, declaration of title. That
So
was
stay means title declared.
no, my lord, but they may.
So I'm asking you, what is the effect of the order of stay passed by the appellate court?
My lord, due to the stay, my lord, they may change, the property might change hands, my lord.
That is a different thing altogether. But what is the effect of stay
My,
of a suit which has been dismissed?
my lord, if your lordship kindly takes up the impugned order once, my lord.
I've heard you. I'm accepted all your submissions, but I'm asking you, what is the effect of that order of stay passed by the appellate court? Is it that the suit has been decreed? That is what I'm asking you.
Suit was dismissed like your lordship rightly held.
So what is the effect of the stay passed by the appellate court? Yes, you are appearing for?
Yes, sir.
I'm leading, leading.
Oh, he is leading you. Yes, sir.
No, he is leading. I'm not very much thorough in the matter. I'm not gone through.
How it is affecting you, sir?
My lord, page number 77.
Malda. The learned advocate for the petitioner submits that without giving an opportunity to the petitioners to contest the prayer for stay, the learned judge of the the learned judge of the first appellate court has stayed the operation of the judgment and order passed in the suit. So we'll stop paragraph. Petitioner is directed to serve a copy of this application upon the opposite parties and file an affidavit of service. No, is directed to serve a copy of this application upon the opposite parties by registered/speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application in the monthly list of January 2024. It is however made clear that pendency of this application shall not be a bar in proceeding with the title appeal number 15 of 2022, which is pending before the Court of the Learned Additional District Judge, First Court at Malda. Yes, next.
Item number 35.
Yes, yes.
If I
Okay, Alia madam, what is the application? What is scan 1 of 2023? Delay condonation of this revisional application. After how much time you have filed?
31 days. 31 days.
After 90 days, 31 days. ও তাহলে এটাও করে দিন। Section 5 টাও সার্ভিসের অর্ডার করে দেবেন। Yes, call the next matter.
My lord, I am for the petitioner.
I am
Yes.
opposing this application.
Yes. Where have you filed the CAN application? Do you have a copy of the application? Give a copy. Put your signature, give a copy. At order record করে দিন। The
My lord, I have just one copy of
make a photocopy,
and then
file it in course of this day, otherwise this order will not be transcribed. করুন। It appears from the cause list that application 1 of 2023 is not available in the records. First up, the learned advocate for the petitioner files a photocopy of such application duly countersigned by the learned advocate on record. First of such copy is taken on record and shall be treated to be original till the original is traced out. The department is directed to trace out the original application and to tag the same along with the records of this case. এটা একদম উপরে দিয়ে তারপরে সার্ভিসটা অ্যাপ্লিকেশনের উপর সার্ভিসের অর্ডার করবে। Yes,
Item number 35.
35, I am for the petitioner, my lord.
yes.
In a suit, I am the defendant in a suit for declaration and injunction. Declaration to the extent.
What order you are challenging?
Order 711D rejected,
Rejected.
rejected. That's why I am before lordship. The ground of challenge is that in a,
Heavily contested matter.
in a cooperative,
Heavily contested matter. Appear, let it appear after the vacation.
আমার suit stay. আমার suit stay.
Yes,
আমার suit stay.
why?
I have not asked for it. I think
Rule without stay, my lord knows better than us.
I have not asked for it.
Rule without stay. My lord knows better than us. I did not utter a single word to that.
Order 7, Rule 11D rejected.
Rejected, not it is not off the cup order 7 rule 11D.
What is the next date fixed in the suit?
I think in November. That's my instruction. That's my instruction. It is in November.
It will take. Cooperative society, the suit, my lord.
I am saying that suit is not maintainable under the Cooperative Societies Act 2006. Barred under 102, Section 102 and Section 92.
Let the maintainability issue be decided as the first issue.
Yes.
Let the maintainability issue
Preliminary
be
issue.
decided as the first issue, along with all other issues that will be decided first. Thereafter, other issues. will be
Others will
decided.
be
But
decided.
once order 7 rule 11D rejected
No, that
Without
will
being
be
influenced by
by
this
this
observation.
order.
afresh.
Reference.
Ashun, the
এরকম করে চল-
এরকম করে চললে তো চলবে না।
the
একটা hearing এ শেষ।
The order dated 1st of June 2023, passed by the Honorable Civil Judge, Senior Division, 9th Court at Alipur, in title suit number 984 of 2022, is under challenge at the instance of the defendant in a suit for
Declaration and injunction.
in a suit for declaration and injunction.
Partition suit dismissed, saying not maintainable.
Yes.
Then he comes and says, I am the 3/5 owner.
That your
Declaration.
energy argue before the suit
That is
court.
permissible. Now it is, my lord. If I fail to obtain consequences and relief, then also declaration is permissible.
The
Not barred under section 34.
Now it is any bar or section 34 amended.
I don't know the Supreme Court laid down the law like that.
the Lanet trial judge, by the order impugned, rejected the application under Order 7, Rule 11, within bracket A and D of the Code of Civil Procedure,
With cost. This was a conjoint order.
with cost,
Cost should be paid.
with cost. Full stop, paragraph. Mr. Mukherjee, Lanet advocate, appearing for the petitioner, submits that the by placing reliance to provisions of section 102 and section 145 of the Cooperative Societies Act 2006,
2006.
Cooperative Societies Act 2006, submits that the instant suit is barred by law. First up, Mr. Rai Lanet advocate, representing the plaintiff opposite party, submits that the Lanet trial judge, after considering the arguments
Plaintiffs opposite parties. Plaintiffs opposite.
plaintiffs opposite parties, there are other opposite parties also.
No,
Plaintiffs
are the opposite parties.
No,
Yeah.
only proforma opposite party is there.
That is
After
the society.
So
appearing for the plaintiffs opposite parties, submits that the Lanet trial judge, after considering the submissions of the respective parties and taking note of the provisions laid down in section 102 and 145 of the said act, observed that the court has ample jurisdiction to try the instant suit. First up, since the maintainability of the suit has been challenged by the defendant, it goes without saying that such issue has to be decided by the Lanet trial judge at the time of final hearing of the suit. First up, yes, you have filed your written statement. No.
No, I don't. I have no instructions.
Uh,
Let this be the preliminary issue
Uh,
after filing of the written statement.
the not really along with all issues.
All
it will be
issues.
decided.
Let this be the first issue. To be
Issue
decided.
number such and such is disposed of by अच्छा देखिए सिविल प्रोसीजर कोड प्रोसीजर कोड
Let them,
जज है वैसे
let them file the written statement because my lord already times. That's why can you direct the wizard that
he has no instructions whether it has been filed or not.
no. Only written objection is filed after rule 1 and 2. After that, order rule 11.
Acha. Yes, Mr. Mukherjee, how soon can you file your written statement?
Immediately after vacation, 1 week, 2
Mr.
weeks after vacation.
Mr. Rai, honored advocate appearing for the plaintiff's opposite party submits that till date, the written statement has not been filed. First stop, since the petitioners filed an application under Order 7, Rule 11 of the court before the Mr. Mukherjee submits that since the petitioners have filed an application under Order 7, Rule 11 of the court, and such order is under challenge in this revision application, the defendants / petitioners herein have not yet filed the written statement. Full stop. Paragraph. Mr. Mukherjee submits that Mr. Mukherjee submits that the petitioners shall file the written statement within the time limit fixed by this court. Full stop. Paragraph. Mr. Mukherjee. Okay. Since the maintainability of the suit is under challenge, this court is of the view that the interest of the parties can be protected if a direction is passed upon the learned trial judge to frame an issue as to the maintainability of the suit after the defendants file their written statement. Only the defendants after the defendants file their written statement. Full stop. It is the learned trial judge is directed to frame. Now, after the pleadings are complete, the learned trial judge is directed to frame the issue of maintainability of the suit as an issue along with other issues that may be germane for the purpose
And
of
let this be the preliminary issue.
deciding
That's
the
my humble submission.
suit. Full stop. It is observed that the learned trial judge, while deciding the suit, shall take up the issue
Under
of
order 14,
maintainability.
under order 14, my lord, the entity points.
Shall take up the issue of maintainability first, and upon deciding the same, shall decide the other issues.
Sir, kindly
in
pause
this
there
suit.
for a moment, subject to question. I don't want to disturb your lordship. Today, my lord, maintainability issue has been decided against me. Then other issues need not be gone into. Then I will prepare an appeal. Then after remand, because it is one issue.
No.
Provided
In this suit, along with it will be decided as the first issue, not alone.
In what
Not
my learned friend is,
not piecemeal.
that my lord can record. Otherwise, my lord,
Yes.
that my lord can record that.
কি বললাম?
Otherwise, my lord, it will create a problem.
কি বললাম এটা? হ্যাঁ। Yes, করে দিন। কি বললাম? Other issues. Good stuff.
Without being
The-
without being influenced by order 711 order.
The learned trial judge, while deciding the issue of maintainability, shall not be influenced, shall not be swayed by the observations and findings recorded while disposing of the application under Order 7, Rule 11 of the Code. Stop with the above observations.
Darshan, the
Time
cost
frame,
the-
time frame.
for
Filing of
filing the
written statement.
The defendant is directed, other defendants also accepting the petitioners, the defendants are directed to file the written statement
within 2
on or
weeks,
before November 24,
another week, because that is 1 week.
You are getting 1 week before vacation. Start preparing, do it within the vacation.
And the cost may be dispensed with.
Cost
The-
of- cost- Legal service. It is not for the benefit of the legal service. is দিতে হবে।
Legal service.
Okay, they legal
Okay.
cost may be
The-
dispensed.
The direction for payment of cost is
Number one,
however
the
set
plaintiff.
aside.
না, না, এখানে দেখো।
এই যে দেখো, এটা দেখো, order
Directions for
711
payment of cost while disposing of the application under Order 7, Rule 11 of the Code of Civil Procedure is however set aside.
It was to the
2000
plaintiffs.
2000 টাকা, না, 5000 টাকা। 2000, 5000
Yes, next.
Some observation
Item
regarding
number
the-
36.
some observation regarding the suit.
Regarding the
Suit.
hearing of the suit,
Some observation.
defendants, no written statement has yet been filed.
That's why if they did not.
Come
file
again.
that,
And it is a suit is not maintained.
I'll satisfy.
Don't act according against your interest.
Yes.
Yes,
But rule without stay, my lord.
yes.
Item number 36.
None appears for the petitioner at the time of call. No accommodation has been paid for either. It appears from the application under order, it appears from the application under Article 227 of the Constitution of India that the ground on which the civil order has been passed is that a date has been fixed for framing of issues by keeping the hearing of the, by keeping the application under Order 39, Rule 4 of the Code of Civil Procedure pending. Full stop. It appears from the record that the hearing of the application under Order 39, Rule 1 and 2, along with the application under Order 39, Rule 4 of the Code was taken up for hearing. Full stop. It further appears from the record that a written objection to the application under Order 39, Rule 1 and 2 was also filed. The learned trial judge, by an order dated April 27, 2023, allowed the petition under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure. Full stop. Since the application under Order 39, Rule 4 of the Code of Civil Procedure was filed for vacating the ad interim order of injunction, and in the meantime, upon a contested hearing, the application under Order 39, Rule 1 and 2 has been disposed of. Nothing survives to be decided on the, nothing remains to be decided on the application under Order 39, Rule 4 of the Code of Civil Procedure. Full stop. The ad interim order of injunction passed stood merged with the order passed under Order 39, Rule 1 and 2 of the Code of Civil Procedure. Full stop. The application under Order 39, Rule 4 of the Code of Civil Procedure shall be deemed to have been disposed of by the order dated 27th of April 2023. With the above observations, the civil revision application stands disposed of. Next.
Item number 37.
Yes.
My lord, I am for the plaintiff. By the impugned order, my application under 151 for police help has been refused. Police help for implementation of order of injunction.
On what ground?
The court has gone wrong in interpreting the order of injunction. It should have treated the order of injunction as it existed, and my lord should have allowed it. But the court has gone discussing the nature of order and consequences.
Show me the impugned order.
Kindly come to the impugned order. The order of the court has gone that this was the interim order and that was the order made absolute.
Where is the order which you are trying to implement?
4th July 2000.
Page.
Order to the Lagaoni to.
You have not annexed.
লাগিয়ে দেওয়া উচিত তো মেন অর্ডারটাই তো ওইটা to order your lordship will find 6/3/2003 is the interim order and the
No, where is the final order which you are trying to implement? You are trying to implement an ad interim or the final?
My lord, it has merged with the final itself.
Where is the final order?
2023.
This is the final.
This is the final. 6/3/2023.
Maintain status quo with regard to possession.
Yes.
Yes.
This is required to be implemented as it exists in the order itself.
And where is your application under section 151?
Last annexure, your lordship will find, my lord. Page 60. It starts from page 59. Sorry, it starts from 59. 59. And the prayer, your lordship will find at 63 and 64. 64 is the prayer to implement order dated 6th March 2023. It should be implemented according to the tenor of the order.
Where is your allegation with regard to this violation?
My lord,
Show me.
paragraph 4, 5, 6. Paragraph 2, police station. Paragraph 9, your lordship will find
9.
2 general diary lodged. Para 8, 9. দুটো ডায়েরি অ্যালিগেশনটা দিয়ে
8, 9, 10.
ঠিক আছে 8, 9, 10. Paragraph 13. General diary is lost. 8, 9, 10, 11, 12, 13 সবই তো একই।
From 8 onwards, it is stated.
There is no scope of entering into the order itself. The order as it stands has to be implemented. The learned judge has got in interpreting the
So why does the trial court say restraining from changing the nature and character?
Because, my lord, the
have
first
said
initial
so.
order was, because, my lord, the interim order was,
No, is it your allegation that someone is trying to change the nature and character?
না না ওইটা হয়েছে যে interim orderটার জন্য interim order দাও because, my lord, this has gone
দেওয়া আছে, দেওয়া
while
আছে,
the
দেওয়া আছে।
interim order was passed, it
দেওয়া
was kindly have a look to the nature of interim order. Therefore, the
When did you file the application under 151?
Oh.
After the ad interim or after the final?
After the final.
after final,
After final.
after final, there is no scope to look into the interim order because it has merged with the final itself.
Oh, initially it was status quo.
Yes, therefore the court has may not gone wrong in finding out the interim, which stands merged with the final order. The court should have only
What is the nature of the property?
my lord, the property
Private
over the
property.
property a declaration that we are,
What is the nature of the property?
it's a private property, restraint order has been sought for.
What is the nature of the property?
My lord, it's
Show me the
kindly come to
property.
the prayer made in the suit itself. Your lordship will find a prayer.
schedule of the plaint.
Page first annexure. First annexure, prayer, page 31, your lordship will find. Page 31, prayer E. This has been granted by the prayer E, page 31.
Pond, bagan, graveyard.
A permanent injunction is sought for against,
Graveyard. This is also suit property.
no, the suit property. Yes,
Page 33.
yes, not page 31. We have prayed for an order of injunction that the record of right in respect of the same is not correct. A decree.
Can that be granted by the civil court?
My lord,
Correct the record of rights?
my lord,
Civil court
that
can
will
pass an
be-
order to that effect.
there are disputed points, but now what has happened, that the order of injunction has attained.
Pond, graveyard,
No, no, your lordship is correct, but the order of
So,
injunction has been made-
application do not specify any particulars, how it has been, possession is sought to be disturbed, nothing.
No, the application specifies it.
I've
Kindly come
seen
to-
the application. Show
kindly-
me what is the nature, how they are trying to disturb your possession. Only
Kindly-
they are trying to disturb a GD entry number.
Page 61, my lord, paragraph.
Yes,
three.
yes.
The, my lord, the order of injunction as it's now.
Have you
has-
brought the judgment of Justice Dipankar Datta?
I have heard, my lord Justice Bhattacharya. That, my lord Justice
The
Bhattacharya.
subsequent one, ad interim order, extended from time to time in the presence of parties.
In that, my lord, Justice.
You want to show that judgment?
Doctor's view was.
You have you got
I
the
have
judgment of Justice Datta?
No, I have not brought. But in that, my lord, his lordship was of the view that so long it is not getting merged with the final order. In my case,
Where?
the order of, my lord.
You have the copy of the judgment.
I have not got. But in my case, my lord, the order of injunction stands merged, injunctions stood disposed of. Now, my lord, once the order of injunction retains on record,
There the parameters have been indicated.
may I serve a
Justice
copy to
Bhatt-
other side and come back? Let them say, my lord, your lord,
Bring the judgment
my
for
lord,
admission that is necessary.
my lord, this is
Bring
the
judgment.
my lord, this is the wrong committed by the court below, that the court has entered into the nature of the order of injunction. Once it stands merged by passing a final order, the court has to accept it. There is no choice on the part of court. Because, my lord, it is the choice of the party whether to accept the order or not. Here, they have not exercised their right to challenge the order of injunction. If, my lord, it has been made absolute, with great respect to your lordship, my lord, if it retains on record, obviously they will have a right to challenge it. But a party, the party accepts it. There is no objection. The application is post-application to ensure that the order of injunction should be implemented.
Mr. Gupta,
as
learned
it
advocate
stands.
appearing for the petitioner submits that the learned trial judge that the order passed by the learned trial judge is perverse in as much as the learned trial judge refused to pass an order of police help on an application under section 151 of the Code of Civil Procedure on the ground that the petitioner has alleged that the defendants are trying to change the nature and character of the suit property. Mr. Gupta further submits that the learned trial judge, while deciding the said application, traveled beyond the scope of the order of injunction. First up, the petitioner is directed to serve a copy of this application upon the opposite parties and by registered post with acknowledgement due and file an affidavit of service on the next date. List this matter in the monthly list of December 2023 under the heading contested application. Yes, next.
The suit is running ex parte. Online, if you're not seen, the suit is running ex parte.
Suit, let the suit run. Pendency,
Item
it
number
is however made clear that the pendency of this application shall not be a bar in proceeding with the hearing of the,
Proceeding with the suit.
in proceeding with the suit. Yes, next.
Item number 38.
I beg to appear on behalf of the petitioner. Defendant number 3 and 4 is the petitioner before your lordship.
I
Let us-
for the opposite party.
In a suit for partition.
One.
In a suit
I'm
for
the
partition.
plaintiff.
Milord, here, Milord, defendant number
Yes, yes, what do you say?
Worship, I believe this is an expeditious hearing, the application
Expeditious
for
hearing.
expeditious hearing.
It's really expeditious, but I should.
But
Then don't make further submission.
No, Milord,
now, my lord,
may I show only 2 things, Milord, before your lordship?
I have something to say.
I mean,
Bol.
defendant number 3 and 4, Milord, is the petitioner before your lordship. In a suit for Milord partition in respect of A,
Suit
B,
for partition.
A, B, and C schedule property. In respect of B and C schedule property, we have pleaded before the court that the self-same suit for partition was being initiated initially by the plaintiff, which was obtain an order of injunction. But after seeing the settlement deed, the court found no, the injunction order vacated. Thereafter, suit got dismissed. Exactly the replica is the present suit. But after seeing that, we prayed for deletion of schedule B and C. Court said, no, you do not have any power to delete the B and C schedule, but the court do have power under order 10, rule 2 to 4, to make inquiry whether this suit is within the knowledge of the plaintiff or not, that previous suit. The affidavit was directed to be filed. That affidavit they have not filed. Time to time, they have extended on one pretext or the other. They have challenged that order also, directing them to file the affidavit by filing a revisional application, which is still pending but not in the list. They have not taken any endeavor.
I have personally,
Then both,
I have taken at
both
least
these
50
revision
affidavits,
applications are to be heard together.
lordship,
Milord,
because it is from the same order.
but they will
If
have,
both of you are challenging this,
I am agreeable, Milord, let this matter be tag with this.
so I am releasing this.
Lordship
You
can
get it assigned.
Milord,
before-
both of us is
I can
agreeable.
come
Milord.
before you, lordship. I
Both
have
of
no
us is
problem.
agreeable. It's not,
I cannot
it's,
take up that other matter.
then Milord, we shall bring that by writing a letter to the Chief Justice, to the Secretary of
After the vacation, has to be, Mr. Mukherjee.
The only difficulty is, lordship, the trial court has fixed, lordship will see
next day
the
is
order sheet. In a
November.
month,
Next date is
3
a month.
dates are fixed.
22nd November is the next date. We shall get it assigned and come back immediately after the vacation before your lordship.
The
Right.
the learned advocates for the respective parties
নামগুলো দেবেন।
jointly pray for an adjournment. Full stop. In view thereof,
On
the
the
hearing of the matter stands adjourned for the day. Next, call the
lordship,
next
I
matter.
record that a similar a revisional application, a similar is pending, lordship. Lordship.
Yes, yes.
Item number 39.
Well, this is my application. The plaintiff is the petitioner is the plaintiff below, in the court below. My lord, the
Petitioner is the,
plaintiff below.
yes.
My lord,
What is the order you are challenging?
my lord, it is order dated 3rd of August 2023. The defendants filed an application for carrying out certain repairs, alleged repairs in an alleged hut, in which they are claiming that there is a hut. We are saying it is a water body. The suit property contains a water body. They are encroaching upon it. That is the subject matter of the suit. In the garb of carrying out the repairs, they want to fill up the water body. That is the only contention. We have stated in our objection filed against their application that there is a water body. The porcha says so. The plan says so.
So the application for repairing has been allowed.
The appeal has been allowed, my lord.
Yes.
The only problem is in the garb of carrying out the repairs, they will try to fill up the water body. That is the subject matter of the suit. I am enjoying an interim order under order 39 rule 1.
So you are protected.
No.
If they do so, you make an application, but you are not aggrieved by the order of repairing.
They actually do not have anything there. In the garb of carrying out.
That you should have pointed out in the court below. Show me that you have made that submission, that it was nothing. And where is your objection to the repairing?
My lord takes up my objection, my lord.
Page,
My lord. My lord, it is at page
what is the suit for?
27. Page 27.
What is the suit for?
Declaration and injunction. My lord, there
You
is
are the plaintiff.
and the plaintiff, my lord. There is a specific averment that there is a water body, Doba.
Page.
It starts at page 27, ends at page 28. The recording is at paragraph 7. 1596 as Doba. Tag number 1596 as Doba. The Porcha also says so. I have annexed the Porcha also. They are trying to encroach upon.
No. This, you have admitted that there is only existence of a heart. So they want to repair that.
My lord, what they will do in the garb of carrying out the repairs, my lord hears it. I will serve them. My lord hears it.
If they do so, you take steps.
My lord, in the
Ashwin, the order dated August 3, 2023, passed by the Learned Civil Judge Junior Division First Court at Barasat, in title suit number 407 of 2009, is under challenge at the instance of the plaintiff. By the order impugned, the application filed by the defendant number 1 for repairing of the Kacha house over the rescheduled property was allowed. Paragraph. The learned advocate for the petitioner submits that in the garb of repairing, the defendant number 1 shall make a new construction. Paragraph. The learned advocate further submits that there is no existence of any room which is to be repaired by the defendant number 1.
After 21 years, a eviction decree was passed in my favor. Now, after 9 years, for my lord, the matter was fixed for judgment in 2022. At the date of pronouncement of the judgment, judge sought for clarification. 2022, we are in 2023. Still, the judge is seeking for clarification. Now has been transferred. Now that
So you want expeditious
disposal of my
of the appeal
filed by the respondent.
It was fixed on 31st of August. What was the next date? What happened on that date?
Nothing happened, my lord.
What is the next date fixed?
30th of November. 30th of November.
13th of November, 30th.
30.
Uh, This is an application for expeditious hearing of title appeal number 31 of 2014, pending before the learned judge 13th bench, City Civil Court at Calcutta. It appears from the record that the hearing of the appeal was fixed on August 31, 2023. So the learned advocate appearing for the petitioner submits that the hearing of the appeal stood adjourned to November 30, 2023. Full stop. CO number 3119 of 2023 is disposed of by requesting the learned judge 13th bench or 12th bench. Because in the preamble you have said 13th, but the order sheet says 12th.
12th is the judge in charge, my lord. My lord will see at the
Oh.
bottom. I was all on that.
The judge,
PO
bench is available.
No, right now it's not available, my lord. My lord will direct, my lord, the judge or the judge in charge, my lord.
The learned judge 13th bench, City Civil Court at Calcutta, or the learned judge in charge to take up the hearing of the appeal on the next date fixed and to dispose of the same as expeditiously as possible, preferably by the
1 month, my lord.
end of January 2024, without granting any unnecessary adjournments to either of the parties.
December, my lord. Right.
This side of the
December, my lord.
November is the next day, 30th of November. So it's end of 1 or 2 days has to be January.
Any.
That is why I have kept it in January. Yes, next.
Item number 41.
Yes, 41. Who is appearing in 41? None appears for the petitioner at the time of call. No accommodation has been paid for either. So in view thereof, the hearing of the matter stands adjourned for the day. Yes, next.
Item number 42.
Application for expeditious disposal of a suit.
Suit.
Yes.
What is the stage of the suit?
Lordship, 7-1 and 7-2 has since been filed in 2021, and that is pending, Lordship.
So now at this stage,
let the application be disposed of.
what is the next date fixed?
Yes, Doctor. Next date
For
fixed
hearing
is on-
of 7-2 is 10th of January 2024.
Yes, yes. Long dates are
This is
being
an
given.
application for expeditious
As
an
well as
application for
written statement.
expeditious hearing of the application under order 7 application under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997. It appears from the record that the hearing of the said petition has been fixed on January 10, 2024. Objections, other things is ready. It's ready for hearing.
Objection has not yet been filed. In the meantime, we will file. We will file, Lordship. In the meantime, we will file. This order was passed.
File
on-
your written objection.
We will file
Without
them.
filing written objection, you have filed an application for expeditious hearing. It was pending for hearing for a long time. Till that you have not, you are responsible for the delay, Mr. Rai.
No, Lordship, let the hearing be held.
Till that you have not filed your application,
No, that
objection.
has not been filed.
Good stuff. On a query of the court, Mr. Rai submits that no written objection to such application has yet been filed. He prays for fixing of a time limit for filing of such objection. as prayed for by Mr. Rai, the petitioner will be at liberty to file written objection to the application under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997 on or before November 30, 2023. First up, if the application under section 7 within bracket 2 of the Act is ready for hearing, the learned trial judge is requested to, the learned trial judge is shall take up the hearing of the application under section 7(2) of the 1997 Act on January 10, 2024 and dispose of the same as expeditiously as possible and preferably on or before evidence and other things has to be done expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Grateful to you.
Preferably ta kete deben. Yes, next.
Item number 43.
43, I am for the opposite party. Lordship, this is my application.
Yes. What is the commissioner's report is rejected?
Lordship, preliminary decree has been passed. Subsequently, survey commissioner has been appointed, and survey commissioner's report has been rejected on the prayer of the defendant. And their contention is that they are alleging that claiming that one vacant plot of land, they are claiming that to be a common road, Lordship, and which the commissioner in his report did not submitted, Lordship, did not file that as a road, Lordship.
If the commissioner's report is rejected, a fresh commission is to be made.
Lordship, but Lordship, otherwise I mean, I am for the plaintiff man in this matter. So Lordship,
There
the
are
report.
two things. If you accept this order, then a fresh commissioner is to be appointed. And if you want to challenge this order, then commissioner's report and other things has to be gone into.
Lordship, I am challenging this order because Lordship, the commissioner has also been crossed, Lordship, by the defendants. And
Then it has to be hard after the vacation. Yes, you have served a copy upon him.
Hey, already I have.
The petitioner, the order number 63 dated April 5, 2022, passed by the learned Civil Judge, Senior Division, 2nd Additional Court at Berhampur, District Murshidabad, in partition suit number 250 of 2014, is under challenge in this civil order. So by the order impugned, the commissioner's report filed on May 20, 2007 stood rejected. List this matter. Have you annexed those commissioner's report and the
I have annexed the commissioner's report and their objection and Lordship the final.
the evidence also?
The evidence as well.
List this matter.
Cross-examination of the. I have annexed that also. Cross-examination.
List this matter under the heading contested application before the regular bench after reopening of this in the monthly list of December 2024. Yes, next.
Item number 44.
Effectively appear for the petition in this matter. My lord, my application for restoration of a suit has been rejected. Now,
Your application for
restoration of suit. Now, my
Yes.
lord, the application ought to have been under Order 9, Rule 9. If your lordship kindly comes up, takes up the order of dismissal of the suit first before going to the impugned order, which is at page 11. Your lordship kindly takes up page 11 first. My lord,
where is the page 11?
page 11. Page 11 is, my lord, the order of dismissal of the suit. Where it says the matter was fixed for peremptory hearing. Plaintiff is absent without steps. Till 12 noon, the learned judge waited, and still the plaintiff was absent, and hence the suit was dismissed for non-prosecution. Lordship will kindly find in the paragraph starting with later. Now, the operating portion is on repeated calls, none appears or moves for plaintiff, considering conduct of the plaintiff through the record being dissatisfactory, also considering the case being pending for last 12 years, and the Honorable Court has already issued case flow management rules for expeditious disposal of cases, and also present conduct of the plaintiff showing no endeavor to adduce any evidence at PH stage. This court has no option but to dismiss the instance for non-prosecution. Now, my lord, my humble submission is, my lord, non-prosecution, if it is dismissed for, it comes within the ambit of order, my lord, order 9, rule 8. Perhaps this cannot be termed as a decree. My lord, kindly takes up the impugned order. Now, there is a mistake on my part. I have, my lord, nomenclatured my application as order 9, rule 4. Perhaps that was wrong, but the substance of the application is, my lord, of order 9, rule 9.
Order 9, rule 9, it has been rejected.
I had my application was nomenclatured as 9(4). Now, my lord, it is said that order 9 does not apply. In the impugned order, it has been stated that the order 9 does not apply at all. Now, my lord, 3 judgments have been relied on. My lord, I'm not carrying the copies of those judgments here, but my lord, I've seen them. I've
According
gone
to
through
you, the miscase was under order 9, rule 9.
them. Order 9, rule 9. It should have been under order 9, rule 9. That is my humble submission.
So order 9, rule 9 rejection, what is the remedy? It is an appellable order.
But my lord, the difficulty had arisen, my lord, since I had nomenclatured my application as order 9, rule 4.
In substance, it is order 9, rule 9.
In substance,
You have to go by the substance.
In
So,
substance, it is.
It's an appellable order.
The lordship kindly gives me the liberty, because my lord, otherwise, because my lord, otherwise, my lord, appeal court could have turned me back.
The learned advocate for the petitioner submits that though the application was captioned as one under order 9, rule 4 of the code, but the same was in effect an application under order 9, rule 9 of the code. Full stop. By the order impugned, the application for restoration of the suit filed under order 9, rule 9, bracket A, wrongly captioned as one under order 9, rule 4, bracket close, stood rejected. So stop. It is settled principle of law that the substance and not the caption of the application is to be looked into. In view thereof, the order impugned being an appellable order, the learned advocate for the petitioner prays for leave to withdraw this application under Article 227 of the Constitution of India with liberty to approach the appropriate forum. With liberty to
The learned applicant.
in
The
view
appellate
thereof, CO number such and such stands dismissed with liberty to the petitioner to take appropriate steps in accordance with law. Petitioner will be at liberty to take back the certified copy of the order impugned upon replacing the same with the photocopy thereof.
Not the time lost in pursuing this revisional application, maybe.
There is a provision in the Limitation Act. You have to apply under that provision.
Lord, may I humbly pray for one more indulgence, Lord? Appellate court, if it is not mentioned, Lord, perhaps not order 9, rule 4, this question will again come up before the learned appellate court. When I approach the learned appellate court, this question might again come up, Lord, since this is captioned as order 9, rule 4. But if your lordship kindly makes
I've
an
said that
observation.
your submission is that wrongly captioned as. I've recorded your submission. Yes.
Deep
Next.
tablet.
Item number 45.
Yes.
Lordship, item 45, I am appearing on behalf of the petitioner. I am praying for accommodation because for the last quite some time, we have been unable to communicate with the client. So In such circumstances,
Ashun, the learned advocate for the petitioner prays for an adjournment. First up, by the order impugned, the application under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997 stood rejected. As prayed for by the learned advocate for the petitioner, let this matter go out of the list. First up, with liberty to mention. First up, the pendency of this application under Article 227 of the Constitution of India shall not be a bar in proceeding with the suit. Yes, next.
Item number 46.
46, I am for the petitioner, plaintiff petitioner, my lord, suit filed for eviction, my lord, the unauthorized occupant, my lord, the trespasser, my lord, dependent trespasser, my lord, there are 4 orders, my lord, kindly see, my lord.
Expeditious hearing you want?
Yes, my lord.
Yes.
My lord,
What is the stage of the suit?
My lord, yes, already, my lord, from initial
already.
stage to, kindly see the orders, 4 orders, my lord, short order, my lord, kindly see the 4 orders, my lord. Kindly see the 4 orders, my lord. My lord, address is
already at this stage.
No. My lord, specific address of the defendant. My lord,
Maybe.
But my lord, court is not considered it, my lord. My lord, I am ready only to file my lord, application for substitution. They have not considered it, my lord.
That is a different thing, but
My lord,
SRAD stage.
kindly see, my lord, the conduct of the court, my lord, from
So Mondol, I am against passing a direction for expeditious hearing at this stage.
kindly see the last order. Kindly see the last order. Kindly
An
see the last.
application for expeditious hearing of the suit. It appears from the record that 18th of
order.
January 2024 has been fixed for service returns, for service returns and appearance. Since the service upon the defendants is yet to be effected, is yet to be effected, is not yet complete, this court is not inclined to pass any directions for expeditious hearing at this stage. With the above observations, CO number 3131 of 2023 stands disposed of. Yes, next.
Item number 47.
47, my application, my lord,
Yes, for what?
for prayer for handwriting expert, my lord. It prayer for, my lord, page 49 and last page, my lord. Order passed. The signature is verification. There is some dispute, my lord, regarding Appointment of handwriting expert, my lord, page 44. DJ handwriting expert, my lord, DJ application. At this stage, I pay for stay, my lord. I shall serve the I pray for my lord stay of this proceeding, my lord. In the meantime, I can serve, my lord.
This application under Article 227 of the Constitution of India is at the instance of you are the defendant,
My lord.
is at the instance of the defendant. And is directed against an order dated June 13, 2023, passed by the Learned Civil Judge Junior Division, Second Court, Tomluk, District, Purbo Medinipur. It appears from the record that the at what stage you have filed this application?
The application, my lord, they filed by the plaintiff, my lord.
It appears from the record that the application for appointment of an handwriting expert has been filed at a belated stage, that is at the time of, that is at the stage of argument. First of the Learned Trial Judge assigned cogent reasons for rejecting the application for appointment of the handwriting expert. This court is therefore not inclined to interfere with the order passed by the Learned Trial Judge. In view thereof, CO number 3134 of 2023 stands dismissed. Next, call the next matter.
Sir, अपना नाम बता दो.
नाम अच्छा था थी. Dismiss.
Item number 48.
Lordship, I appear for the petitioner husband. Before Lordship applies his mind to this matter, Lordship, the impugned order pertains to quantum of maintenance to be paid. Lordship, the wife has also preferred a civil division assailing the same order. She's appearing as item 574 in the list of Justice Shampa Sarkar. If subject to your Lordship's convenience, I was suggesting both could be heard together.
Ashun. This application under Article 227 of the Constitution of India is at the you are the husband.
Husband, Lordship.
Is at the instance of the husband challenging an order dated 19th of May 2023, passed by the Learned Additional District Judge, Second Court, Howrah, in Miss Case number 70 of 2018, arising out of matrimonial suit number 357 of 2016. First of the Learned Advocate for the petitioner submits that the wife has also challenged the self-same order by filing an application under Article 227 of the Constitution of India, being CO number
2087
of 2023, and the same is appearing in the list before the Honorable Justice Sarkar. So, in view thereof, let this matter go out of the list. This court is of the considered view that the revisional applications, this court is considered that the aforesaid that the revisional applications, one at the instance of the husband and other at the instance of the wife, challenging the same self order, is required to be decided analogously. In view thereof, let this matter go out of the list with liberty to the petitioner to take appropriate steps.
I'm grateful, Lordship.
Go out of the list, না করে release from the list করে দিন. Let this matter be released from the list of this court. Yes, call the next matter.
Item number 49.
I am for the
I
petition.
appear for the opposite party plaintiff, my lord.
Yes,
Lordship, can you come to last one order which passed holding that the court has no jurisdiction actually. My lord, the actual order have preferred this revisional application against the order at page 13.
page 13.
13, my lord.
But where is the certified copy?
Certificate copy, that is what I have preferred before the learned district judge.
Last order, my lord, is the
And that
certified
is-
copy.
Yes, what is the order under challenge?
And I have challenged this order. Actually, this is rejected. And I have paid for the examination of witness some questions. That is barred, my lord. Lordship, that is in page 13. Page 13. And in the meantime, what happened, my lord? The learned closed the evidence and fixed the date for the it was the 11th of Joseph.
This is the certified copy.
Certificate copy, my lord, but latest order closed the evidence and placed for argument.
The impugned order.
When the pending, I have informed that the case is pending before the Honorable High Court.
The impugned order is passed in an application under section 115 of the CPC, my lord. In
The
which it
learned
said
court
there
that
is,
the-
because it does not adjudicate finally, revision application is not maintainable under 115. Dismissed.
And this is against the order at page 13, my lord, dated 3rd May 2023.
What is the proceeding?
Proceedings for the eviction.
47.
47.
In section
Execution,
40
in the
Sorry.
execution proceeding.
What do you want?
My lord, the examination of the witness, that is, my lord. And in the meantime, my lord,
This was
learned
with- I'll
judge-
indicate, my lord, this was
What
with-
is the infirmity in this order? Show me.
well, that is my, he only hold that I have no jurisdiction. That is the land.
That is the revisional code.
Code number.
That is the
page 13.
revisional code. Now you are challenging the parent order.
Yes, my lord.
You are challenging the parent order or you are challenging the main order?
That is not.
They are challenging the order dated 25th of
Yes,
July. my
that
lord.
is,
They
it
are
is
challenging-
anything.
They have it.
Yes, my lord.
Impugned
Oh.
order is 25th of
So, my lord, the losses can see whether I can examine the witness or not, my lord.
You have to challenge that order then. You have not challenged that order.
My lord, I have
This order,
challenged.
there is no wrong.
District just said that I have no, my lord. That is
Yes,
not since
rightly so.
said that I have no, because the case is pending before the trial court. That is this.
Yes, 115A, no jurisdiction, rightly so.
Sure. Yes, no, man, then I have to come before this Honorable High Court. So I have come and my lord,
But you have
annexed
to
it.
challenge the parent order. That you have not done.
And that is what I have annexed. That is the page 13.
Annexing will not do.
Then
Where is your challenge with regard to that? Nothing, no grounds. You have challenged only the order passed in the civil revision application.
that is not.
Certified copy is also not there.
My lord,
So
so my lord, that is otherwise you will also grant me liberty to take the certificate copy and place.
beyond
with,
this,
press,
No,
if you
look,
want to, you can withdraw this.
my lord, in the
But
minute
I
losses can see order passed in the my lord.
That
Close
is-
the everything, close everything. That is my lord.
beyond the scope of the civil division.
Now I can only see the order passed in civil revision. If you want to make any submission on that, yes. Otherwise, you have to
that is my
withdraw.
lordship.
You have to withdraw and challenge that.
My lord, that is my losses can you see the order, they have closed the evidence. That is the problem.
Then you have to challenge this order.
Otherwise, the losses can you see the order. Last
You have to challenge this order, sir. I've seen that. Argument of the petitioner in default. So 20th of November.
So I cannot take evidence. That is also my lord.
You have to
Evidence
challenge-
was there.
You have to challenge this order and the earlier order.
Then my lord, return it, my lord. I'll liberty to,
So do you wish to withdraw this? This revisional application?
I have liberty to file a fresh. Liberty
Mr. Chakraborty, learned advocate appearing for the petitioner,
Well, in the meantime, my lord, losses can be some.
prays for. No.
Well, I have to take certificate copy of this order, my lord, the trial court order, my lord. That is my lord.
কি বললাম? The তার আগে লিখুন The order number 2 dated 25/7/2023 passed by the learned District Judge Hooghly in Civil Revision number 8 of 2023 is under challenge in this revisional application. Is under challenge in this application under Article 226 of Civil Revision under Article 227 of the Constitution of India. After going through the impugned order, this court finds that the learned district judge was right in holding that the application under section 115 capital A of the Code of Civil Procedure was not maintainable. At this stage, Mr. Chakraborty, learned advocate for the petitioner, submits that he has instructions to challenge the order dated 3rd May 2023 passed in title execution case number 2 of 2015. He prays for leave to withdraw this revisional application with liberty to file afresh.
And this
In view thereof, CO number such and such,
this
sends
liberty
this
matter not to
with
close the
liberty to file afresh in accordance with law on the self-same cause of action. Yes, next. You take back this. You have taken back.
yes, madam.
Yes, next. Call the next matter.
Item number 50.
50, my lord, is my application, my lord. My lord, it is an application for waiving of the 6-month cooling off period in a mutual divorce proceedings, my lord. Section 28 of the Special Marriage Act. My lord,
What is the latest view of the Supreme Court? What is the latest judgment on this?
my lord, Amit,
There are conflicting views. What is the
my lord, I
latest
will
view?
rely on Amit Kumar, my lord. Amit Kumar Suman Beniwal, my
What
lord.
has been held there?
Also division bench of the Calcutta High Court.
My lord, in this case, my lord, it is under 13B, my lord, one petition, and application was moved for waiving of the 6-month cooling off period in the family court, which was rejected. Then 227 was filed, that was also rejected. Supreme Court held that the family court and the trial court have gone wrong and set aside both the orders.
This is under 142, sir.
My lord, 142, my lord.
This is under 142.
Yes.
So,
My lord, may I submit, my lord? My lord, there are certain conditions which have been laid down. If those conditions are
142.
satisfied,
this is under
my lord,
142.
142 is granting the decree for divorce without relegating them to the family court once again.
Yes.
But my lord, for waiver of the
Show me
6-month
that
period,
the district judge has the power to waive this. Show me the finding in this.
yes, my lord, here, this case has,
Show me only that part.
my lord, this case has relied on Amardeep Singh versus Harleen Kaur, my lord. Now, my lord, paragraph number
You are from the
I
other
am the
side.
consenting wife. I am the consenting wife. I have filed my wakalatnama on 25th.
No, it is on both parties.
What has been done here?
My lord, we have taken out an application for waiver, my lord, under 151. That has been rejected, and that is the impugned order.
6 months period is to expire when?
My lord, 6 months. Actually, my lord, the fact is that we have previously also filed a mutual divorce, but under section 13B. So there we have waited for the entire period of 6 months. But then we had to not press that application. That was before the district judge at Purbo Mendipur. Thereafter, we have filed
No,
another.
when this petition for mutual divorce has been filed? When?
My lord, the first mutual divorce petition was filed on 15/12/22.
No, this one.
This current one, my lord, has been filed in 2023, my lord.
When? What is the date?
Yes, my lord, 10th August 2023. So we have already waited the 6-month period, my lord, previously. And due to that technical error, my lord, we had to not press that application in Midnapur.
Actually, we are separated for 16 months.
Yes, and we have stayed together only for 1 month, my lord, after the marriage.
There is no chance.
And there is no chance of reconciliation, my lord.
Yes, which judgment you have referred to?
My lord, Amit Kumar versus
Oh, here in this past in transfer petition 100-1118. The judgment you have relied upon in the court below. Where is that?
Major court of conduct. এইটা তো এইটা রিলাই করেছিলেন মধ্যপ্রদেশ। My lord, that judgment probably is not available with us, my lord.
You have placed that before the trial
My
court.
lord, right
So
now here, my lord.
bring that tomorrow for orders.
Tomorrow, my lord.
List this matter tomorrow under the heading for orders. For orders, Lord.
Grateful.
For orders, item number 2.
Who I beg to appear with the petition. This matter relates to, my lord, impoundment of the, my lord, penalty regarding, my lord, stamp duty.
Yes.
What has happened, my lord? Agreement for sale was executed in the year 2009, August 2009. My lord, thereafter, the earnest money was paid only 5,000 at that time.
No, which is the order under challenge?
My lord,
16th of January.
16th of January, my lord.
Yes.
My lord, earlier occasion, my lord, it was referred to the collector for, my lord, assess the.
No,
my lord,
this is the, you are challenging the order dated 16th of January. What has been done?
my lord, 16th of January, my lord.
Yes,
may
that is the
submit-
order under challenge.
Yes, my lord, may submit this, my lord. My lord, on earlier occasion, it was referred to the collector for, my lord.
No, no, that is in this order, what has been done? You are challenging 16th January. What
16 January, my lord, the learned court below was satisfied to remain the, my lord, said same, my lord, decision of the collector.
No, no. In that view, kindly place the order dated 16th of January.
Learned, my lord, from the second paragraph, may I? Learned advocate for the side of the contesting defendant submitted before this court in view of earlier orders. There appears no ambiguity in this particular record regarding the process of impoundment, except the point that the defendant may further prefer an appeal against the order of impoundment as per procedure established by law. In that view of the matter, learned advocate for the plaintiff not press the petition preferred on 24th June 2015 under order 39 rule 1 and 2 seeking temporary injunction on such petition being not pressed. The learned advocate for the
Yes.
contesting.
So you are challenging this imposition of cost.
My lord, my lord, only 1,000 rupees was imposed by the collector, my lord.
No, no, you
Your
are
lordship may
directed to
find
pay cost of rupees 250.
250.
Against
No,
that, you have prepared a
I'm not,
civil division.
I am not that on that part, my lord. I am on the.
You have challenged, this order says only that, nothing regarding other things.
My lord,
Today is fixed for hearing on the point of report.
my lord.
Thereafter, this.
My lord,
Thereafter,
if your lordship,
further examination, nothing has been said on impounding. Only the imposition of cost.
impounding, my lord, the report of impounding, my lord, remains same. Kindly come at, my lord, page 16.
You are not
Kindly.
challenging the report of the today's fixed
That
for
was the
hearing.
second time it was submitted. That was the second
Nothing
time.
has been submitted on the report. You have only not pressed this application.
That is the
Ashok.
only earlier application, my lord. My lord, kindly, my lord, for a moment, my lord, kindly come at page 16. Kindly come at page 16, my lord. My lord, from the
yes,
my lord, after 3 lines, learned advocate for defendant submits referring non-filing of show cause by plaintiff and report sent by collector and amount of penalty written thereon in violation of rule that is only rupees 1,000. My lord,
Yes.
consideration amount is, my lord, 1,65,000.
Then report from the collector.
Collector,
Yes, what happened after that?
that remains same, 1,000 rupees. For reconsideration, it was sent by the learned court. And the collector, my lord,
That has been deposited 8,865.
stamp duty.
Yes.
And my lord, regarding the part of the penalty, that is only 1,000. I'm on
You are
that.
challenging, it should be more.
My lord,
So that you have to challenge this order. This is not the order at the challenge. 21st of August 2017 is not under challenge.
my lord,
You have challenged 16th of January
that
2020.
reflects, my lord, from the 16th January, my lord.
Ashun, this the order dated 16th January 2023 since I am not inclined to take up this matter on personal ground, let this matter stand released from the list of this bench. Petitioner will be at liberty to take appropriate steps.
I'm grateful, ma'am.
For orders, item number 3.
আগেরটা কেটে দিন, কেটে দিন। শুধু এইটাই থাকবে, রিলিজের অর্ডারটা। কোনটা কোনটা? আগেরটা, হ্যাঁ।
I'm grateful.
I'm opposite party.
Yes.
So, my lord, sorry, I filed a written submission the other day on Friday regarding of eviction. They have filed an application section 10 to stay my suit.
What is the other suit? What are the two suits?
The one is for declaration and injunction that was filed.
Declaration of what? What declaration?
Declaration of the half share in the property, and the other one is for eviction.
Where is your written submission?
I filed it the other day.
Yes, you have filed. কোথায় গেল?
I filed it with an annexure, my lord, the other day.
এখানে একটা ছিল, রিটেন সাবমিশন দিয়েছিল, যে কোথায় গেল?
May I hand over?
But that annexure, he has.
That annexure, I can give you a copy of that, my lord.
Huh? I think I've returned it to you for making a copy.
No. I gave them a copy.
Do you have a copy of that order which you have annexed?
Yes.
Because I don't find here.
Not an order as such. It's I have to find it out. Yes. This is the annexure. So in a nutshell, what actually I'm praying for is that just one point that I want to make out.
Give me a minute, I will call upon you. Yes.
So I just want to make one very pertinent point, my lord. If you kindly have a look at the impugned order at the end of the application, at the very end, the third page, and if you see the second last paragraph, that's the entire gist of the order. That's the observation of the learned trial court, based on which the order was framed. So if you look at the entire order, the basic necessity of a Section 10 application is to actually fix the matter in issue, what the matter in issue in two suits are, and to find out whether they are similar or substantially similar or not. If you see the order, the learned court has absolutely not gone into the matter in issue at all. So it has not got into the, and that I have actually highlighted that in my submissions also. So the matter in issue needed to be framed. Leave alone framing, the learned court did not even mention it ever in the order, that the matter in issue is in focus, which cannot be the case in a Section 10 application. The matter in issue is the main thing. So whether the matter in issues are similar or substantially similar, that has to be, because without that, you cannot actually pass an order, but the learned court has done that. And the second thing is that the learned court could not have gone into the merits of the case, of the individual cases. But the court has, if you look at the order again, the court has mentioned very clearly that the title belongs to the plaintiff. But how can the court actually do that? The court only had to look at the issues, whether they are similar or not. The court had no business to go into the merits of the individual cases. So it has done that. I have written that in my submissions also. And it has also said, interestingly, that it has also said that the nature of the suits are different, are different. That's why in section 10. But nature of suits can be different, but the matter in issues have to be considered. So the nature of suits involved cannot be a valid criterion in deciding a section 10 application. That is what the learned court has done. So these three are my main contentions. But the most important contention, the most important submission that I want to make, my lord, is that the court could not have framed this issue without looking at the matter in issue at all. The court has not gone into the matter in issue, what the core issue, what is the
Where is the plaint of your suit?
the plaint is it's page 16 to 32, page 16, my lord. 16. So can I make one more point here, my lord? So during the section 10 hearing, the other side, throughout the hearing, we had 3 days of 3 dates of hearing. The other side kept on talking about the title, the right, title, and interest in the suit. So they said every time they claimed that they are the absolute owners. If you look at their the eviction suit plaint also, they have claimed to be the absolute owners. And based on what? Based on the right, title, and interest. So, but if that is the contention of the other side, and if they keep on hammering on that point every time, but that is what we have actually claimed for in our suit, the previously instituted suit. So the matter in issue, actually the core issue, if you look at it, the core issue remains the same. But the learned court has not gone into that. The learned court, if you see the impugned order, my lord, the learned court has said the nature of the suits, but that cannot be the valid criterion.
Issues are to be seen.
The issues are to be seen. The learned court hasn't gone into it at all.
Anything more?
So that is my main contention. That is what I have said, and that is regarding the order, my lord. I'm not. I have not. I have not submitted anything in front of you regarding the section 10 per se. If you ask me, I can start talking about the section 10 and why I want my application to be restored. Well, the one that has been rejected by the trial court. That is what I'm saying. So in that particular case,
you want to argue more, then it is to be after the vacation.
Yes, I would like to do that, my lord. I would like to do that, and I would like my lord to take give it a consideration so that it can be adjudicated in a manner which looks into the matter in issue, whether they are similar or not, and whether section 10.
For that, the plaint you have filed,
right,
written statement of 2 suits, I will consider that.
Yes, and also their objection.
You have also filed your written submission.
I've filed everything.
Yes, Mr. Saul.
My suit for eviction. My suit is eviction, and their suit is declaration, and they have filed 2019. Thereafter, no step. Their intention to delay them. That's why they have in my suit first one of the defendant filed an application.
Claim to be the owner.
I am the owner. I have everything. Title deed, everything.
See, that is what I'm.
Title deed, right title, interest, everything.
Take your seat. You have a chair behind you. Take your seat. Yes.
Right title, interest, deed in my favor. I have filed for eviction. They have filed a declaration 2019. Thereafter, not.
What is the relation between both of you?
Brother.
Why are you not settling this?
I think I don't know what is the matter, but what is going on. But I think long years.
When you are here,
no,
it can be settled.
No, it is very difficult. It is very difficult.
Very difficult.
Very difficult. Today's situation is not like
right.
that.
Yes, you make a
substitution. My suit is for eviction, and their suit is for declaration. And they have filed in 2019. Thereafter, not take any steps.
According to you, issues are not same.
No, not same. And their pair was not forceful eviction. I am not forceful. I withdraw.
Anything more?
No, Lordship.
All right.
Lordship, both.
Heard the learned advocate for the parties.
Can I just make one
Hearing
submission?
you have filed your written submission.
Sure.
Hearing concluded, judgment stands is up. Yes, call the next matter. Call the next matter.
Item number 51.
Milord, in this matter, Mr. Kushal Pal is appearing on behalf of the petitioner, Milord. He kindly make it not this week due to his sudden demise of his wife, Milord. Kindly make it not this week.
As prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for this week. Next.
Appearance to the bench. Yeah, action for the day. Item number 52.
Yes. Yes. Look at the front, not at the back. Yes.
Permission to draw electricity.
Permission
to effect electricity connection has been allowed. The super partition and draw lordship attention about the application which has been filed.
So what is the application which has been disposed of?
Reason for praying to direction to the concerned authority to effect electric connection to the plaintiff. Well, can turn
What
to
is
page
this suit for?
super partition.
Suit for partition.
Dear Malar, can you consider what is the application? Page 27 once.
Page 27.
Yes.
Your application.
No, their application.
Oh, that has been allowed.
That has been allowed.
Page 27. Yes.
Your lordship will find the first allegation that after filing of the suit, receiving the summons, defendant number 1, defendant being agreed by such and such as antisocial nature and connected with the political party on such and such, destroyed the dwelling house, mud house of the plaintiff in absence of them. After returning at home, plaintiff became depressed and with the help of entered into the incomplete building. Plaintiff entered into the incomplete building of the defendant number 1 and staying there from the said night, which is still continuing as mentioned in paragraph 20A of the plaint. The present staying there, no electricity connection. Now the plaintiffs are using
the opposite party here.
Yes.
No, not in.
Now, man, can you consider on the basis it is his allegation that I am forcefully entered into the property and I am residing there. On the allegation that I have destroyed the building as per their allegation, be as it may. Now, man, can you consider the learned trials court order? Now,
only electric connection without claiming any equity.
Man, can you consider what is his prayer and what is his claim on the allegation that forcefully entered the defendant's property and I am staying there and I want an electric connection to that place. Well,
unlawful occupier, occupier, person in occupation
now, my lord,
is entitled.
Now, occupation, my lord, settle occupation, my lord. Unauthorized occupant, my lord, this honorable court held, my lord, the honorable officer said, went up to honorable officer, said, settle possession. I am not on that. Occupation must be settled. Somebody's saying.
After all, he is your co-sharer.
I am not admitting me as it may, even if the co-sharer, he is admitting the construction.
You have filed the suit. No,
they filed a suit.
So it seems that you are co-sharers. So you will get one portion of the property.
It is constructed by me. Defendant of construction, it is their case.
It will be decided in the suit.
No, it is their case itself.
So how the suit is maintainable then?
That comes later. That application has already been filed. Now, what is his case? That after that, now one can consider I want to draw your lordship's attention over that portion. Paragraph 3. That after filing of the suit, receiving the summons, defendant number 1, defendant being agreed and defendant 1, 2 are antisocial in nature and connected to political party on such and such. Defendant destroyed the dwelling mud house of the plaintiff. In absence of them, and after returning home, plaintiff became depressed and with the help of the local plaintiff entered into the incomplete building of the defendant number 1 and staying there from the said night and which is still continuing as mentioned in paragraph 20 small a of the plaint. At present, the plaintiffs are staying there. There is no electric connection. Now the plaintiffs are using the ground and first floor of the incomplete and illegal construction of the defendant. So if, my lord,
an arguable point has been raised by Mr. Rai, learned advocate for the petitioner, as to whether the plaintiff who claims to have entered into an incomplete building of the defendant number 1 can pray for electric connection. So the petitioner is directed to serve a copy of this application by registered / speed post with acknowledgement due and file an affidavit of service
Well,
on the
I'm
next
not,
date.
there is no question of stay because this is a order, my lord. I do not know whether any condition has been effected or not.
I'm
If
only
any
direct-
condition, I'll record that if any condition is made in the meantime,
That will be in the final.
otherwise, I'm not inviting a lordship to pass any mandatory order to that respect or anything. If any condition is made in the meantime, that will be abided by the result. Otherwise, my lord, today my lord is there, my lord is hearing the same. Tomorrow,
Is this matter before the regular bench in the monthly list of
this
side of the vacation, Mr. Rai. I'm trying the matters. I'm fixing some
that I am acknowledging, my lord. That is
in the monthly list of December 2023. Any steps taken
yes.
in terms of the impugned order dated July 18, 2023 shall abide by the result of this.
Because I have heard that condition, temporary condition has been given in the theatre. That's why, my lord, I am not asking for the stay.
Any steps taken, that is why.
Yes, that's
Yes.
I can
Next, call the next matter.
Item number 53.
53.
Well, in a suit for declaration and permanent injunction, the plaintiff.
For the opposite party.
Lord, I'll take a day's time to assist your lordship, Lord. There
What
is
is the impugned order?
Well,
a stay granted by the appeal court of an injunction.
Stay
Granted by the appeal court at the ad interim stage against an order of injunction.
Against.
But I know, Lord, what falls from your lordship. There are 2 judgments, Lord, that I will show.
He
I'll be
says-
arguing. No, I'll be arguing on the point about, Lord, the stamping of, Lord, the agreement.
That is
That is-
pending before the
No, Lord, even this high court
Impounding.
division bench, at the stage of, Lord, the injunction, whether the question of, Lord, the sufficient stamping, whether can be gone into by the court or not.
Sir Mukherjee, that issue is pending before the Supreme Court.
But that
A
is
review
fine.
application has been filed.
Lord, that is
That is
there.
also pending.
But so far as not our High Court division bench,
Sir,
I'll show, Lord, what the
Directly
division bench
matter
says.
to go to be listed after the vacation. Argue.
2 judgments, Lord, I'll show, Lord, thereafter I'll rest my case. Or take it after vacation, Lord. Whichever way, Lord, I'll not be putting pressure on your lordship to hear this matter.
Because if you want to argue,
But I'll be assisting your lordship, Lord.
no, this thing means if it is a contested matter, then you
Yes.
have to apply the mind. It's difficult in this side of the vacation because motions I'm trying to pick up. Or I can do one thing.
Lordship.
I can only adjourn is for this day. If I
Lordship.
complete once, I can come back, I will.
Very well.
Ashun.
Very.
Mr. Mukherjee, learned senior counsel representing the opposite party, prays for a day's accommodation. Such prayer is allowed. The hearing of the matter stands adjourned for the day. Yes, call the next matter.
Lordship.
Item number 54.
Pass over next.
Item number 55.
I am for the petitioner. My application under section 10 has been rejected. For that reason, this application has been prepared. Initially,
Stay of suit.
yes. Initially, first I have filed a suit for declaration of the title and along with a permanent injunction. Thereafter, the eviction suit was filed by the defendant. And in the meantime, my lord, thereafter I filed an application under section 10 of the civil procedure code. And same has been rejected. My lord, kindly come to the impugned order. The type copy has already been annexed. The ground, the court finds that the outcome of the title suit number 22, this is my suit, is crucial decisive and significant for this suit, but waiting.
What is the date of the order?
My lord, 23rd March of 2020.
Yes, yes.
But the waiting for a prolonged time of the outcome of the suit, halting process, proceed in the suit is bad in legal logic. Suppose even after the outcome of
No,
the
no, I do not.
no, the type copy has already been annexed.
Oh, yes, yes, yes. Yes.
The last paragraph of the first
What are the two suits for?
First one is the declaration of the title.
Your suit is for declaration of
Yes,
title.
yes. And
Yes.
second one is the preferred by the opposite party, that is eviction.
Yes.
I filed an application under section 10 of the for the in respect of the
Eviction suit.
Eviction suit. My lord, now my lord, kindly come to the last paragraph of the first page of the impugned order. The court finds that the outcome of title suit number 22 of such and such is crucial, decisive, and significant for this suit. But waiting for a prolonged time for outcome of that suit is halting process to proceed in this suit is bad in legal logic. Suppose even after the outcome of the title suit number such and such, this instance suit needs to complete in its procedure.
No, submits that the title suit is before the appeal court. Why? Suit has been decreed.
No, my lord.
Learned advocate for the plaintiff submits the title suit number.
No, my lord. My lord, I have filed a misappeal. Same is pending.
Misappeal for what?
My lord, there is.
It says the appeal court. You are the plaintiff in this suit.
In respect of the 22 of 22.
Yes.
But
It's pending before the appeal court.
Appeal court. But that is misappeal is pending. And for that reason, I filed this application under section 10 in respect of the title suit number 28. The learned trial court has rejected my application only on the ground that it will take time.
All right, come tomorrow. Na 54 থেকে এই ডাকবেন। Next matter.
Was only seeking for a copy, my lord.
Who is for the other side?
56 and 57.
Where is the petitioner? Petitioner is not here. Do you know who is the petitioner? Take 56, 57 briefta din. You ask copies from them.
Item number 56.
ডাকতে হবে না, এমনি কপি গুলো দেখ। অনিমেষ পাল, 12,015. You have the mobile number. দেখি পরেরটা দেখি।
Same matters. Two suits.
Same. So you get the number, call him. দেখতে হবে না, ওনাদের দেখান ওই যদি নাম্বারটা এ করে আসুন।
Lordship will be taking up tomorrow. Lordship will be taking up tomorrow.
Tomorrow from 54, item number 54.
Lordship.
ঠিক আছে 54 থেকে কল।
স্যার এক মিনিট।